The Fed Upward Podcast, a place for federal employees and friends of feds to find strategies and tactics to navigate everyday problems.
Collective bargaining is a powerful tool and a powerful hedge against change.
And now, a quick word from our sponsor.
From launch pads
and liftoff
to research labs, civilian Fed life leads to many places, all covered by WAPA. WAPA offers fully portable group term life insurance for current and former civilian Feds. This coverage answers whatever life brings, with benefits that follow wherever service calls. WAPA. For Feds, by Feds.
Hi, Feds. This is Love Rutledge, host of the Fed Upward Podcast, and I'm kicking off an episode today, right now, that I know you want. Because you want to understand what your rights are as a federal employee moving into 2025. A lot of anxiety out there, a lot of folks who are nervous about what might happen. And so I've got an attorney here who has worked inside government, who handles employment law cases now on the outside. And so he's been in every role imaginable, handling federal employee law cases. Kevin Shehan, thank you so much for being on the show.
Thank you for having me.
So I want to start by saying what this episode will not be. It will not be a political screed or a political statement. It will not be an ad for Kevin, although I think he's great and his services are great. This is an opportunity to level set and make sure people have information. So don't consider this legal advice that you need to go follow immediately, but rather, again, level setting, baselining information for federal employees so that they know what their rights are now and they know what may be in jeopardy in the future. So Kevin, with that, I'm going to turn it over to you to talk about what employee rights look like right now and then what they might look like in the future.
Well, I appreciate that. And Love, I want to echo your sentiment. This isn't political. When I was launching Shehan Legal in 2020, there was a documentary that was popular on Netflix, and it involved Michael Jordan and the '98 Bulls. And he said something that's relevant for today, which is, he said, Republicans buy sneakers too. And I'll say Democrats buy sneakers too. And Green Party, individuals buy sneakers too. And, I represent people of all across the political spectrum. And this isn't political. It's about federal employee rights. So I just wanted to echo your sentiment. I couldn't agree more. The folks that you work with in government and the folks that I represent in government are on all across the political spectrum and all sorts of different parties. So this isn't political whatsoever. So yeah, I echo that sentiment.
Thank you for that.
Absolutely. And I do want to echo something else. This is informational. It's not legal advice. I have, for example, a blog, and I'm going to say a little bit of a disclaimer that I use with the blog, and I use it in any of my interviews as well. This is informational. It's not legal advice. Don't take or fail to take any action based on this information. It's for you to be informed. And if you need legal representation, that's when you reach out. But, don't take this and try to be a lawyer yourselves. That's my advice to you. So with all of that preface, and I guess, I'm a lawyer, so I had to give that preface.
Of course.
Let me talk about federal employee rights. And I do want to look at two areas. I want to look at what rights are now, and I do want to look ahead. I'd like to start by looking ahead. Now, I have found that when looking ahead, it can be helpful to reference the past, especially because the incoming administration has been an administration in the past. We have some previews as to what the new administration might be interested in doing. And we also have some, statements and proclamations and hints at what they might be doing. So I'm going to tie that all in. The first thing I want to talk about, and I'll get to talking about Schedule F. I'll get to talking about DOGE. But I actually want to start in a place that maybe fewer people are talking about, but I think more people should be talking about. And that is the Department of Veterans Affairs Accountability and Whistleblower Protection Act of 2017. That law was, passed by Congress and signed into law by President Trump at the beginning or towards the beginning of his administration. And for the employees at the Department of Veterans Affairs, they're very familiar with this law, but it's possible that outside of the VA, there's less familiarity. And I want to introduce your listeners to and your viewers to this, because that law, which had a significant impact on the civil service rights of Department of Veterans Affairs employees, or many of them, was viewed as a bit of a roadmap, something that could, in a future Congress and in a future administration, become law and apply to federal employees across the government. So this VA Accountability Act, as it was called, it did two basic things. Number one, it lowered the Department of Veterans Affairs' burden of proof when proving disciplinary actions. Okay, employees that are familiar with disciplinary actions, maybe you're an HR, maybe you're a manager, maybe you're an employee who is familiar with policies, maybe you've been the subject of a disciplinary action. Your familiarity with this is that you're probably used to hearing that the burden of proof is a preponderance of the evidence. Not under the Accountability Act. It was lowered to what's called substantial evidence. And it's a much, even though it has the word substantial in it, it's a much lower standard and imposed a much lower burden of proof on the VA. The second thing that the VA Accountability Act did was it took away the MSPB, in other words, the Merit Systems Protection Board, ability to mitigate a penalty. So you may have heard of the idea of, if you're facing a removal, maybe the deciding official will mitigate that penalty from a removal to a suspension. Pardon me. Well, the Accountability Act took away the VA's ability, the MSPB's ability to mitigate penalties. And so for any employee that was facing a removal, it was off the board to review or try to mitigate that down. That's a big deal. There's a significant number of cases where employees are saved from removal through mitigation. Now, I do want to make a note about the VA Accountability Act. Court rulings later overruled parts of the law, and the VA, in fact, stopped using it under the Biden administration. But it seems to me that with congressional action, there could be an opportunity to retool the law in a way that would pass court scrutiny. And with congressional action, it could be something where a similar law is passed to apply to the entire government. So I just want to put that out there as something that folks should be aware of as a potential development on the horizon.
That's a perfect place to start, Kevin. Thank you for that background, because I think that sets the stage for the other topics that you want to go into. So what do you have next for us?
Next is Schedule F, something that folks might remember from the end of the Trump administration. It was issued under Executive Order 13957. It was issued October 21st of 2020, and it really did one basic thing. It declared that employees whose work involved confidential or policy matters no longer had civil service protections from removals, etc. In other words, they were at-will employees who could be fired freely. Now, the current administration did two things with respect to Schedule F. First of all, in 2021, the Biden administration withdrew or rescinded that executive order, which is something that administrations can do. One administration can rescind an executive order of a prior administration. So the Biden administration rescinded that executive order, number one. And then number two, there were regulations that the current administration issued regulations through the notice and comment process to try to get ahead of Schedule F. And what I mean by that is these new regulations declare that a person has MSPB appeal rights if their position is subjected to a Schedule F type reclassification. And so what I mean is the act of being reclassified, right? That employment action triggers the appeal right itself. So I just wanted to put that out there. There's been some attempts to hedge against a new Schedule F, but we've already got express indication from the new administration that I believe the quote is that it's a day one priority. So employees should be aware that there's going to be some, playing out of this in the litigation process, I would think. and we'll see how it shakes out, but there are some protections in place, and so people should be aware. A new Schedule F could be coming, and there are some new rights to be aware of with respect to that.
A quick word from our sponsor. For more than 20 years, Clearance Jobs has connected professionals with federal government security clearances with employers to fill the jobs that safeguard our nation. The Clearance Jobs career community allows members to connect, engage, and explore opportunities and helps contract and government employers find talent. Create a free profile and learn more at www.clearancejobs.com.
Okay, what's next on your list, Kevin, for all the things that federal employees should be thinking about? Any myths you can bust about some of the things that have been said in the press?
Absolutely. So I'm sure one of the things that folks want to hear me talk about is DOGE, the Department of Government Efficiency. As we know, Musk and Ramaswamy, are the two high-profile individuals who the current, the incoming administration has said that he wants those individuals to run this Department of Government Efficiency. The stated purpose of that department is to cut the federal workforce. I want to say a couple things about it, and this isn't intended to be controversial at all. It's just meant to be matter of fact and informative. So number one, DOGE doesn't currently exist. It's not been legally established, and until it is legally established, it does not have any direct authority to do anything. However, even if you have this idea of DOGE, and even if it's not been legally established, there are still certain things to watch for, and I've identified at least 3 reasons to watch DOGE and to consider its potential influence, even if it's never formally constituted as an agency or a bureau or any sort of advisory board. So number one, a stated reason, as I said, for DOGE being created was to slash the federal workforce or cut the workforce. So think about firings. And something that DOGE could do is amplify the agenda of instituting new Schedule F reclassification. So think of DOGE as something where Musk can go on, his platform X and start touting the need for Schedule F and should try to, raise that to be more high profile and get more support behind it. And then that could lead to, more adverse action. So that's one thing to keep in mind, that through just influence alone, DOGE could trigger potential, removals. The next thing is layoffs. DOGE could express recommendations, for example, to revoke telework across the government and to move agencies from one location to another in order to trigger the shedding of the workforce. If there's people that need telework and it's taken away, they're going to be put on the horns of a dilemma. Likewise, if an agency is moved from Washington, D.C. to Houston, Texas, just as an example, that's going to put people on the horns of a dilemma. Are they going to, geographically relocate, just to keep their federal employment? So there's this indirect layoff procedure, essentially, that could be triggered just through policy changes, and those can always be recommended by this, this entity, even if it's never organized. Now, the last thing I wanted to mention, also relating to layoffs, is there could be some direct effects that DOGE has, again, even if it's never established, to put pressure on Congress to cut budgets and trigger formal reductions in force. And so that's another thing to keep in mind. So, DOGE doesn't exist right now, and so it's hard to know exactly what to expect. But even if it's never formally established, these are 3 things that I think people should keep in mind.
Thanks for that rundown, Kevin. Again, really appreciate it. So those are sort of the previews we have of things that could happen that have been signaled either in the press or by President-elect Trump himself or some of his advisors. Can we take a step back and talk about what civil service protections exist right now, what law looks like, and what folks need to know about the current state of play?
Absolutely. We took a few moments to try to look into our proverbial crystal balls and see what the future holds. And I think it's good to do that, to try to be prepared and anticipate, but it's also good to look at the present. What are rights that federal employees have right now? And I've come up, this is just my list in no particular order. What I think are the top 5 existing employment rights that federal employees have right now. Number 1 is collective bargaining rights. Now, those apply only to union members, but there's union members across the federal government. Collective bargaining is a powerful tool and a powerful hedge against changes. For example, taking away of telework, which I mentioned when we were in the crystal ball section of our discussion. So the Social Security Administration recently reached an agreement with the American Federation of Government Employees, AFG, and it was determined that under the new collective bargaining agreement, telework rights are established under that agreement, that employees who meet certain criteria are going to be able to telework. And so there's going to be a bit of a legal speed bump in attempting to take away telework from Social Security Administration employees, for example, because it's provided for under a collective bargaining agreement. So that is a really concrete example of a really set of important rights that employees have if they're union members. So that's number 1. Number 2, civil service rights. In other words, protections in the face of adverse actions, disciplinary actions. For a litany of adverse actions, there is a right to a reply. I'm talking about removals, demotions and greater pay. I'm talking about suspensions. I'm talking about furloughs for 30 days. And if we're talking about appeal rights, you have appeal rights for all of those, with the exception of suspensions. Those must be greater than 14 days for you to have appeal rights to the MSPB. But in any event, there's a broad array of disciplines where you have, even without an appeal right, you initially have your right to a reply to a proposed discipline, and in some instances, the right to appeal to the MSPB. These are very important rights. A vast number of my clients are facing, come to me because they're facing disciplinary actions. And so I know from experience, this is a very, very, very important set of rights. And while there's things in the crystal ball that could interfere with these rights, these are rights that are in place right now, and until they're not, you have them. So that's number 1, or number 2, excuse me, on the list. Number 3, EEO rights. Employees across the federal government have the right to initiate an EEO claim if they face discrimination or harassment on an EEO basis, or if they face retaliation for engaging in protected activity. And as many federal employees know, you initiate those claims through your agency, and after you get through a certain point in the processing, namely after the investigation and after a report of investigation has been issued, you have the option to litigate that claim before the EEOC if you'd like to, or you can take a different path that'll get you to federal court. But the point is, government-wide, employees have these rights. And what I would say is, if you think about that list I just gave you, number 1 was union rights, number 2 were these disciplinary civil service rights. Not everybody actually has all of those number 1 and 2 rights that I listed, but these EEO rights apply to all federal employees and applicants for employment. So I would say the EEO rights are important and notable, not only for the subject matter they cover, but for the breadth, right? There's this broad net that's cast, and they probably cover, the most people of any of the rights I've just talked about. So that's number 3 on my list. Number 4, whistleblowing rights. The right to make a disclosure to the Office of Special Counsel, the right to make a protected disclosure to the Office of Inspector General at your own agency. Federal employees have the right to blow the whistle on wrongdoing. And I mean violations of law, rule, or regulation. I mean abuse of authority. I mean gross mismanagement or gross waste of funds, or actions that create what's called a substantial and specific danger to public health or safety. when federal employees become aware of these types of wrongdoing, they have the legal right to make a disclosure either to OSC or the OIG, and these rights are established in the Whistleblower Protection Act and established in the regulations that govern OSC and also the various OIG offices. So these are very important rights, and whistleblowing serves a very important purpose in government, just to say that in general. So it's something that, the saying about sunlight is the greatest of disinfectants. Well, whistleblowing rights are part of that sunlight for sure. And then related to whistleblowing rights, I'm going to call this OSC rights. In other words, Office of Special Counsel rights, rights against prohibited personnel practices, which includes whistleblower retaliation. So, and 14 other set of rights which are covered under the prohibited personnel practices or PPPs. So the Office of Special Counsel has the authority to investigate and prosecute violations of the 14 PPPs, and those include, as I said, whistleblower retaliation. It includes coercion of political activity. So in other words, using one's station to leverage, others in their own agency, or to leverage anyone to engage in political activity. Another PPP is obstructing or influencing competition. There's nepotism. There's abuse of authority. There's 14 of them. I won't list them all. You can go to the MSPB website or the Office of Special Counsel website to see the whole listing. But this is my number 5 on the list: people's OSC rights to complain about and oppose these prohibited personnel practices.
So, Kevin, you've talked us through the rights we have currently. You've talked us through some of the things that folks may be concerned about in the future that we're hearing about in the press. Can you remind everybody who's listening when it makes sense to retain an attorney? We've touched on this in previous episodes, and I want to remind folks that if you are in a situation in your agency or department where you feel like you need representation, keep in mind that the government's level of protection that they provide in terms of attorneys is to protect the agency, not necessarily to protect you. And that applies all the time, regardless of who the president is and regardless of who the leadership in your agency and department might be. So can you remind folks what that situation looks like? And then again, what suggestions you have for when people should look to retain an attorney?
Yes, that's a very important topic. I'm happy to address it. And I say this having been in the federal government before law school, during law school, after law school. I at one point was an attorney representing my employing agency in, employment related claims. And, I know from that experience that we were really told from day one to be clear with folks. When the agency attorney is talking to you about a personnel matter, they don't represent you. They represent the agency. Now, that doesn't mean that agency attorneys are bad. I was an agency attorney and I didn't view myself as bad. And I don't view agency attorneys as bad now. They're serving a very important role. But you can't rely on agency attorneys for individual legal advice for you as the employee. Yes, of course, you're using agency counsel to help you in your work, right? That's different than your personal employment or your individual employment. It's a conflict. They cannot represent you. So the question that you asked, Love, was when do you talk to a lawyer? And one way to answer that is the moment you're thinking about whether you need to talk to a lawyer is probably when you need to talk to a lawyer. And frankly, as I've found over the years representing folks, a lot of times it's actually earlier. What I would say is, if folks have heard me in other interviews, I've said this before, these processes, I just went over my top 5 list of rights, and these rights tend to coincide with various processes. And these processes present themselves as user-friendly. They present themselves as something that you can navigate without a lawyer. And what I would say is, if there's an issue that's come up that's important enough to engage those processes, it's important enough to talk to a lawyer about it. Don't go it alone. Don't try to DIY or self-help. you can really compromise your rights and lose out on things that you're not situationally aware of. And, I think that if you have an issue of concern that's important enough, as I said, to engage with these rights, engage with a lawyer about it. And I'm not just saying that, out of self-interest. I'm saying that out of interest for the federal workforce.
Yeah, absolutely. I appreciate you revisiting that topic. I think it's one that people don't realize is important until it's too late. So thank you for reminding folks about what they should keep in mind. I also want to give another reminder to folks that federal employees can purchase professional liability insurance. There are a couple of different companies that offer it. I personally have it because I think it's just a good idea. You never know when someone may file a claim and you will need support in a process from that perspective. So check that out. The two companies that I'm aware of that offer that specific federal employee protection is a company called Feds Protection and another called Star Right, and that's WRIGHT. So check those out, see if that makes sense for you. Kevin, is there anything that we've missed that you want to highlight for folks, or any specific places they can go for resources? And then if you could end things letting them know how they can get in touch with you if they'd like to learn more about your services or your blog.
Yes. Well, there's lots of informational resources out there. I mentioned some of them as we went, including the MSPB website and the Office of Special Counsel website. I'll also mention my website, shehanlegal.com. That's www.shehanlegal.com.
Thanks so much, Kevin. I really appreciate it. And again, I hope folks don't need to use these resources, and that we are secure in our employment and that we know our rights. But you never know what's coming on the horizon. It's important to stay educated on, again, your current protections as a civil servant, and to think about what may be coming so that we can all be educated and hopefully lower our anxiety levels, folks. I know that right now is a time where people are asking a lot of questions and aren't quite sure where to go for answers. So I hope that this episode with Kevin has maybe quelled some of your fears, maybe given you more information so that you can be well educated moving into 2025.
Thanks for listening, friends. If you liked what you heard today, I hope you'll subscribe to the podcast and share it with a friend. To join my mailing list, head over to fedupwardcoaching.com/podcast. Talk soon.